Do you remember the last time you sold your home and filled out a mountain of paperwork with your realtor? You probably walked away from the closing table thinking, well, it's done, that's it, it's behind me, it's not my problem anymore. On to my new home. Well, what if I told you that there is one form you filled out at your kitchen table that could follow you for 5 years after closing and cost you hundreds of thousands of dollars? Yes, because it can. And today I'm going to show you exactly how. Hi, welcome back to my channel. I'm Darlene Harwick, Realtor for Resort Cities in Coachella Valley. And today I'm going to talk about a document most sellers don't think about until the demand letter arrives. And that form is the Seller Property Questionnaire, the SPQ. Now in California, it's technically part of the transfer disclosure statement, but whatever you call it, here's what matters. It is not optional paperwork. It is a legally binding document, and the way you fill it out determines whether you're protected or exposed. Now, I know what some of you are thinking. Darlene, I've sold homes before. I filled out the forms. Nothing happened. And you might be right. Most transactions close without a problem. But here's the thing. I'm not here to talk about what usually happens. I'm here to talk about what can happen. Because in California, the law gives buyers a very long leash to come back after you. Listen to me closely. Under California Civil Code Section 1102, every seller must complete a transfer disclosure statement covering the physical condition of the property. Yes, you have to disclose a leaking roof or a cracked foundation, but you also need to disclose any renovations, remodels, or additions, and whether permits were pulled. You must know past insurance claims, water damage, or mold, even if you believe you fixed it. You must disclose deaths on the property within the last 3 years, and if there have been any neighborhood nuisances or HOA disputes. And here's where sellers get tripped up. Even if you repaired the problem, you still have to disclose it. There was a California case that established this back in 1983 called Reed versus King. The court ruled that a seller must disclose any fact that affects the property's value or desirability, meaning if the seller knows about it and the buyer couldn't reasonably discover it on their own. And that last part, that's the part that matters. If you know about it and they can't see it, you have to tell them. I forgot is not a defense. Selling a home as is not a defense either. As is does not absolve you from disclosing what you know. That's California law and has been tested in courtrooms for over 40 years. The form doesn't ask what you think the buyer should care about. It asks what you know. And the gap between those two things, that gap is where the lawsuits live. Now let's talk about what actually happens when the buyer discovers you weren't accurate. First, you're going to get a letter, probably from a lawyer, and it'll use words like material misrepresentation, failure to disclose, and fraud. And at that moment, the burden shifts to you. The buyer can pursue several claims in California. Negligent misrepresentation, meaning you should have known and didn't disclose. Fraud, meaning you actively concealed or misrepresented a material fact. And breach of contract, because that disclosure form is part of your purchase agreement. And what can they recover? Repair costs, every dollar. It'll be the difference between what they paid and what the property is actually worth. And don't forget the lawyer fees. And in California, many contracts include fee shifting provisions, which means if you lose, you pay their lawyer too. And in fraud cases, it is punitive damages. Damages designed not to compensate, but to punish. Now, sellers, listen up. In California, the statutes of limitations for fraud in real estate is 3 years from the date of discovery, not from the date of closing. If it takes 2 years for water damage to become visible behind a wall, the clock starts then, not when you sign the papers. There have been cases where buyers filed suit 4 or 5 years after closing. Think about that. You've moved on, you're in your next home, maybe even another state, and then you get served over a house you sold half a decade ago because of what you wrote on one form. Let me show you what this actually looks like in real life, with real sellers who sat exactly where you're sitting now and paid a steep price for what they left off the form. There was a buyer who purchased a home and discovered that a bathroom remodel was completed without permits. Now, the seller had done the remodel himself and proudly listed it as updated. Worse, the unpermitted work had a flaw. The shower pan wasn't properly installed. Water had been leaking into the subfloor for months. Repair estimate? $25,000. And because the seller had marked on the SPQ that all renovations were permitted and completed professionally when they weren't, the buyer had a clear case for fraud. Now, I don't believe the seller was set out to deceive anyone. He probably thought he did good work. What does a permit matter? That's not the seller's call to make. Permits exist because they require inspections. Inspections catch what the homeowner eye misses. When you skip this step, you take on the liability. This seller didn't think he was being dishonest. He thought he was being reasonable. He probably thought, well, close enough, nobody will care. That was years ago. But the form doesn't care what you think is close enough. The law doesn't care. And when a buyer discovers something you didn't disclose, neither do they. So you're not just selling the house, you're selling the house with a warranty, a legal warranty that everything you said about that property is true to the best of your knowledge, and that warranty doesn't expire at closing. And don't use the word newer when you've replaced windows, doors, roofs, HVACs, basically anything. And don't let your agent write in newer when describing your house in the MLS. Newer is open to interpretation. Newer to you may mean within 5 years. Newer to a buyer may mean within 1 year. Provide the dates when you replaced or repaired something, and always keep your invoices and scope of work documents. Those invoices will be your proof. So remember, never say newer, and always keep all invoices, receipts, and scope of work from people who did the work. So by now you're probably asking, well, Darlene, how do I make sure this doesn't happen to me? The answer is actually quite simple, although it does require some discipline. Over-disclose. If you're not sure whether something counts as a material fact, disclose it anyway. If you had a leak 3 years ago that you fixed, disclose it. If you replaced windows without pulling a permit 10 years ago, disclose it. If the neighbor's dog barks every morning at 6 a.m., disclose it. The SPQ is not just another form. Be exhaustive filling it out. Think of it this way. Every single thing you put on that form is a shield. It's evidence that the buyer knew and that they made their decision with full information. And that means they can't come back at you later and claim they were deceived. And please keep your records. Keep all inspection reports, repair receipts, warranty documents, and contractor invoices showing permits were pulled. If a question ever arises 3 years later, your documentation is your defense. And work with an agent who takes disclosures seriously. When I hand you that SPQ, I'm going to tell you what I'm telling you now. Take your time. Read every question. Never guess, never assume, and never leave it blank because you hope it won't matter. Take an extra minutes on your disclosure forms. You want to know that you've done everything on your side to be honest, transparent, and protected. You want to sell your home and actually have it stay sold. Sellers, you need to be thorough, honest, and protected, from the SBQ all the way to the closing table. Now, if you're considering listing your home, I think my Market Insight Guide could help. It's free, and the link is below the video description. And don't forget to subscribe so you won't miss my market updates. Finally, contact me if you're ready to start looking, start planning, or just have questions about selling your desert home. Well, thanks for watching, and I'll see you in my next video.